Hi, my name is Kelsey Davis, and I am a compliance consultant at the League of Southeastern Credit Unions. Today, we're going to discuss fair lending. Let's talk about what it is and why it's important to you and your credit union. So, fair lending ensures that everyone has access to lending opportunities without discrimination. There are a number of fair lending laws and regulations, and each one of these are important for you to understand. So, some of these laws and regulations you may have heard of before. We've got the Home Mortgage Disclosure Act. It's also known as the HMDA, and that lives under Regulation C. There are NCUA regulations that we all need to follow. Fair Credit Reporting and Consumer Credit Protection Act, the Fair Housing Act, or the FHA, and the Equal Credit Opportunity Act, or the ECOA. These are the most common regulations and laws that you're going to hear and be dealing with. So let's start our discussion by looking at the Fair Housing Act, also known as the FHA. The FHA was created in 1968 as part of the Civil Rights Act to prohibit discrimination in the sale, rental, and financing of residential dwellings. This means that financial institutions cannot discriminate against a potential borrower based on race, color, national origin, religion, sex, and this includes sexual orientation or gender preferences, familial status, so families with children under the age of 18, pregnant women, or people securing custody of children under 18, and disabilities. The FHA is so important because this is what has enabled millions of people to purchase their first home within the United States. It was created to protect the rights of these purchasers. Next, let's talk quickly about the Equal Credit Opportunity Act. You may have heard this referred to as the ECOA. The ECOA makes it illegal for creditors to discriminate against individuals throughout every part of the credit process. The ECOA is housed under Regulation B and applies to all creditors. The purpose of the ECOA is to promote availability of credit to credit-worthy individuals by prohibiting discrimination based on race, color, religion, national origin, sex, marital status, age, or the use of a public assistance program. These prohibitions are in place throughout the entire lending process, so before, during, and after the extension of credit. There are a few ways that the Consumer Financial Protection Bureau, also known as the CFPB, I'm sure you've heard of them before, there's a few ways that they enforce these lending laws. Firstly, they use a risk-based approach to prioritize supervisory examinations and enforcement activity. They do this by monitoring key consumer financial markets to identify developments and trends. Next, the CFPB utilizes other factors such as tips or leads. These may come from a number of different places: whistleblowers, advocacy groups, consumer complaints, analysis and exam results, and there's other data they look at as well. If you've ever visited the CFPB's website, you would notice that there's a place prominently on the top for consumer complaints. That's something they really look for and rely on. The CFPB also prioritizes redlining, discrimination in underwriting and pricing, and Home Mortgage Disclosure Act, or HMDA, data integrity. So, why is fair lending important to you? Why should you care about it? Firstly, let's think about your consumers, your members. Credit unions were created with the intent of serving their members and their communities. So it's so important that everyone within those communities has access to sustainable lending, and it's our responsibility as lenders to facilitate this. But now let's think about it as an employee. Simply put, it's illegal to treat consumers differently based on a prohibited base factor. If you were found to be in violation of these laws and regulations, you could face legal consequences and some hefty fines. So it's important to note that no one is perfect, and there may be times that we are inadvertently discriminating. These actions may be identified and corrected without penalty. Here's an example of discriminatory lending and its potential consequences. In 2021, the CFPB teamed up with the Department of Justice to bring legal proceedings against Trustmark Bank for their discriminatory lending practices. Ultimately, Trustmark paid a total of $12.85 million in fines and penalties, not to mention all of the time that they had to spend in court with this. And these are just a few important things to understand about fair lending penalties. Penalties can be doled out to companies and individual violators, and these penalties can include damages, fines, orders to alter practices, and additional damages for legal fees. Regulators monitor for willful noncompliance and negligent noncompliance, and creditors that fail to comply with fair lending requirements are subject to civil liability for actual and punitive damages. There are three main types of proof of discriminatory lending. This is overt evidence of disparate treatment, comparative evidence of disparate treatment, and evidence of disparate impact. Let's talk about what each of these mean. So, firstly, overt evidence of disparate treatment. This happens when lenders openly discriminate on a prohibited basis. Here are two examples so we can get an idea. First, let's say that a lender offers a credit card with a limit of up to $750 for applicants aged 21 to 30, and a card with a limit of up to $1,500 for applicants over 30. This policy would clearly be in violation of the ECOA's prohibition on discrimination based on age. Secondly, let's look at an example where a lending officer tells a member, "We do not like to make home mortgages to Native Americans, but the law says we cannot discriminate and we have to comply with the law." Even though the lender may be complying with the law, this statement violates the FHA prohibition on statements expressing discriminatory preferences. It's also in violation of Regulation B ECOA. Next, let's talk about comparative evidence of disparate treatment. This occurs when a lender treats a credit applicant differently based on one or more of the prohibited bases. This is likely to occur in the treatment of an applicant who is neither clearly well qualified nor clearly unqualified for credit. Here's a quick example of what this might look like. A non-minority couple applies for an auto loan. The lender found adverse information on the couple's credit report. After discussing this with them, it is discovered that the adverse information is incorrect. The non-minority couple are granted the loan. A minority couple apply for the same loan with the same lender. Upon discovering adverse information in the minority couple's credit report, the lender denies the loan application on the basis of adverse information without giving the couple the same opportunity to discuss the report. Now, let's talk about what exactly is evidence of disparate impact. So this happens when a lender applies a racially or otherwise neutral policy or practice equally to all credit applicants, but the policy or practice disproportionately excludes or burdens certain persons on a prohibited basis. I know that's a mouthful, so let's look at an example. So maybe a lender's policy is not to extend loans for single-family residences for less than $60,000. This policy has been in effect for 10 years. This minimum loan amount policy is shown to disproportionately exclude potential minority applicants from consideration because of their income level or the value of the houses in the area in which they might live. This is a great place to stop and talk about redlining. So, redlining is an illegal disparate treatment practice in which lenders provide unequal access to credit or unequal terms of credit based on race, color, national origin, or other prohibited characteristics of the resident of the area in which the credit seeker resides or will reside, or in which the residential property to be mortgaged is located. Here are a few examples of different types of evidence of discrimination. So firstly, there's selectively encouraging or discouraging individuals who inquire or apply for credit. There's also refusing to extend credit or other different standards in determining whether to extend credit. There are varying the terms of the credit being offered to different types of people, using different standards to evaluate collateral for different people. There's treating a borrower differently in servicing a loan, and also using different standards for pooling or packaging loans in secondary markets. Laws and regulations against discriminatory action also apply to co-signing of a loan. It's discriminatory to require a co-signer on every loan in which the borrower is a woman. It's also discriminatory to require a spouse to co-sign if the borrower is married. So, what about marital status? Can we make inquiries about this? Typically, no. When an applicant applies for individual credit, a lender cannot ask marital status with the exception of the following situations. So, firstly, the credit transaction will be secured. It might be a good idea to ask marital status because this information may help determine what would be required to gain access to the collateral for the loan in the event of a default. Also, if the applicant resides in community property states or list assets to support the debt in the following states: Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, Wisconsin, in those states, in this situation, you can ask for marital status. Here are some requirements for when you deny a credit request and send an adverse action notice. A written notice must be provided within 30 days of the counteroffer or the adverse action. A written notice must be provided within 90 days after notifying an applicant of a counteroffer if the applicant does not expressly accept or use the offer. All right, so that is an overview of fair lending and everything that it requires, why it's important to you. If you have any questions about fair lending, anything in this presentation, or any other regulatory or compliance questions, we would love to hear from you. You can get in touch with myself, Kelsey Davis, at this email address, kelsey.davis@lscu.coop. Tony Roberts, he is our senior compliance consultant at tony.roberts@lscu.coop, or just send general questions to our whole compliance department at compliance@lscu.coop. Thank you so much for spending some time with me and looking at this very important lending practice.